Electronic disclosure, often called e-disclosure or e-discovery, has revolutionized litigation across the globe, demanding new protocols and technologies to handle the flood of digital data. In the UK and Canada, courts emphasize e-disclosure protocols, technology-assisted review, TAR, and careful consideration of metadata, all balanced by the principle of proportionality. The US leads with sophisticated e-discovery systems, incorporating cost-shifting measures and sanctions to manage the complexity and expense of electronic evidence. The EU focuses on strict e-evidence regulations, GDPR compliance, and cross-border data rules, making privacy a top concern. Australia is rapidly expanding its use of e-discovery, especially in large or complex cases. Across all jurisdictions, mastering electronic disclosure is now essential for effectively navigating modern litigation. Legal advice privilege is a fundamental concept that protects confidential communications between a lawyer and their client made for the purpose of seeking or giving legal advice. In the UK and Canada, this is known as legal advice privilege, while in the US, it is called attorney-client privilege. In Australia, it is referred to as legal professional privilege. By contrast, in the EU, the protection is rooted in professional secrecy, which is an obligation for lawyers but not a direct client right. Despite these differences in terminology and scope, the core aim across all jurisdictions is to encourage open and honest communication between clients and their legal advisors. Litigation privilege protects documents created for the purpose of actual or contemplated litigation, ensuring that parties can prepare their cases without fear of disclosure. In the UK, Canada, and Australia, this concept is known as litigation privilege and covers communications and materials produced in anticipation of legal proceedings. In the US, the parallel doctrine is called the work product doctrine, which safeguards materials prepared by or for attorneys in anticipation of litigation. By contrast, in the EU, such privilege is limited or often absent, with a greater emphasis placed on the lawyer's duty of professional secrecy rather than a specific right for clients or their legal teams. Despite these differences, the underlying aim is to protect the integrity and strategy of the litigation process. The without prejudice rule is a vital legal principle that protects the confidentiality of settlement discussions and negotiations. In the UK, Canada, Australia, and the US, communications made without prejudice cannot generally be used as evidence in court, encouraging parties to resolve disputes freely and openly. While the EU does not specifically recognize this rule, similar protections may arise from broad confidentiality principles. Ultimately, the aim is to foster honest and constructive settlement talks by shielding them from later disclosure. Public interest immunity, PII, is a crucial legal doctrine that allows courts to withhold certain documents from disclosure if releasing them would harm the public interest, such as compromising national security or sensitive government operations. In the UK and Australia, this concept is explicitly known as public interest immunity, while in Canada, it is referred to as public interest privilege. The US employs the state secrets privilege, and the EU has similar doctrines to protect vital state interests. Despite differences in terminology, these protections serve a common purpose: balancing the need for transparency in legal proceedings with safeguarding critical public concerns. Proportionality is a guiding principle in modern litigation, ensuring that the scope, cost, and value of legal proceedings remain balanced and reasonable. In the UK, proportionality is central to managing the extent and expense of disclosure. The US embeds this standard in Rule 26(b)(1), which requires that discovery be proportional to the needs of the case. The EU enforces proportionality through the Damages Directive, while Canada and Australia incorporate it explicitly in their procedural rules and court practices. As this comparison shows, while the core principles like privilege and proportionality are recognized internationally, each jurisdiction brings its own nuances and emphasis.